Hello students, it's HP Dlamini again. Now we are doing module 9, Public Law N6, Sources of Administrative Law, Public Law N6 book and South African Constitution are my references, and yours it's only the Public Law book N6. So in my introduction, we are talking about the administrative law. So we are bound to talk about the origins, that is the sources. And we must know as to who makes laws and where does law come from? Where can we find the law in order to apply them to a specific case? The sources of South African administrative law. Remember, this is not the sources of South African law. It's sources of South African administrative law, right? The first one is the Constitution, right? The Constitution is the most important legal rule. Most important legal rules are found in the Constitution, right? The other one is legislation, statutes, ordinances, regulations, and proclamations. The components of legislation as a source of administrative law. It's parliament, provinces, proclamations, regulations. Then let's start with parliament. Parliament is the highest organ that passes legislation, right? And provinces. Provinces are authorized by Parliament to issue ordinances. Proclamations are just act of saying something in a public, like in a public, they use documents. It's in a document form, but it must be said in a public. Regulations are written instruments having the force of rules established by primary and or delegated legislation. Take for example with the regulations from the Disaster Management Act of 2000. The very same regulations are the cause for your staying at home right now. The very same regulations keeps you indoors as I speak, right? So those are regulations. Then there are written instruments containing rules having the force of law. The second one, another source would be the judicial review, that is the legal verdicts from the courts. The Constitution empowers the courts with a testing right in order to protect the rights of citizens. When the courts find legislation unconstitutional, court may declare it invalid after approval by the Constitution. We spoke in the previous modules, we spoke about this in that whenever the High Court finds something unconstitutional in a certain legislation, they may declare it invalid, but they will have to wait for the approval by the Constitutional Court. Judicial review also gives courts the authority to review administrative actions. For example, take a teacher who's teaching somewhere. The Department of Education may not just transfer a teacher without the teacher's opinion. In other words, they must hear the other side. That is what we're talking about when we talk about the aude alteram partem, which is a principle of natural justice, right? Another one is common law. When a matter is not governed by legislation, common law usually applies. For example, murder, rape. So murder, everybody knows that murder is a common law crime. Even the person who's not conversant with the law knows that murder is a crime, even a child, right? Common law developed from the RDL, Roman Dutch law, as well as British law. This then forms the basis of common South African law, and it is binding. From Roman Dutch law and British law, certain common law principles applied. You can see them there on page 72. They are so important in such a way that I may not be surprised to see them in the exams or in your coming tests. Those are common law principles which we received from Roman Dutch law as well as British law. Okay. Customary law or administrative practices. Court has to decide whether a specific custom amounts to law, as well as courts too requires that an administrative practice must fulfill the following: long time, reasonable, observed generally, certain and clear. An example in this case would be ilobolo, for example, as a customary practice. You will remember that in Module 1 or Module 2, we also spoke about the custom, where we spoke about the findings of the appellate division, in that case of the fishermen, that is Van Breda and Jacobs. Those are all customary laws, right? And the Constitution allows that the customary people, the traditional people, must also develop their customs, their customary laws. Indigenous law, it takes a form of unwritten customary law, and the Constitution gives the right to the traditional authorities to develop their own law. Indigenous law can be applied in ordinary courts if the parties choose so. For example, if there is a case which needs indigenous law, the two parties, the two litigants, must agree first that indigenous law will apply in that particular case in order to help the court to arrive at a suitable decision which will suit both litigants. Another source would be the writings of modern authors. Writings of old authorities or common law have a binding force as a source of law. Academics and other lawyers write books and articles in journals that are useful source from which we find law. The academics, usually the new academics who are using journals and all that, they would critique maybe the previous or the old authorities, but their bases are from those old authorities. They take their writings, they research further, and they will find that some of those things are no longer valuable for us these days, but some are still valuable. This is the end of Module 9. I thank you, and I promise you with Module 10.